Stanford University.
This program is brought to you by the Stanford Humanities Center. For more information, please visit us at shc.stanford.edu.
So I want to start just by showing you my grandson, Alexander Jack Rakove, down here with our daughter-in-law in the National Portrait Gallery, and along with a portrait of James Madison. Our family were mostly Madisonians. That's just the way it is. So our subject for today is I want to talk about Marbury versus Madison, the great case of judicial review. And I'm going to present a somewhat contrarian account of it. Actually, the title for today's lecture would be a great prompt for the midterm. Which mattered more, Marbury versus Madison or McCulloch versus Maryland? And while that won't be the prompt for the midterm, it will be something I think pretty close to what you're going to wind up doing. So I'd like to use this lecture to try to set up a framework for something we'll ask you to think about over the next couple of weeks and probably get you a prompt. So I want to start by setting Marbury in its proper context. And one context is the one you might remember I set up a couple of weeks ago when I lectured on 3 myths about the Constitution. The last one, the one I talked about fairly briefly, was the idea of the judicial review, the idea that courts should have a capacity to subject the ordinary acts of government to constitutional review. There is a kind of standard line in American history which says this is a very problematic, a very doubtful, a very uncertain notion. And I think the great academic statement of that idea comes from the famous work by Alexander Bickel, The Least Dangerous Branch. And it appears on the very first page of Bickel's analysis. This, by the way, this is a work which dominates and still deeply informs modern constitutional theory. So it's kind of a great counterpoint or a kind of great pivot upon which to think about all the issues we've been arguing about pretty much since Brown versus Board, or actually even earlier. So as Bickel said, Congress was created nearly full blown by the Constitution itself. The vast possibilities of the presidency were relatively easy to perceive and soon inevitably materialized, and that's actually a key point. But the institution of the judiciary needed to be summoned up out of the constitutional vapors, shaped and maintained. And the great Chief Justice, John Marshall, not single-handed, but first and foremost, was there to do it and did. If any social process can be said to have been done, and done is put in interior quotes here, at a given time and by a given act, it is Marshall's achievement. The time was 1803. The act was the decision in the case of Marbury versus Madison, and the act was the decision in the case of Marbury versus Madison. Now, this idea that Marbury is somehow formative, that it is by itself a kind of critical turning point in American constitutional development, it's an idea that I think is often propounded in law schools. And Marbury is a class that's is a case that's actively taught. Although there are contrarians, including friends of mine, somebody like Sandy Levinson, a pretty well-known law professor, University of Texas, who argue exactly the opposite, who argue actually that Marbury versus Madison ought to be excluded. So I think it's worth our starting and asking, because we want to know why is it we frame the questions we do in the way that we do it, where does the cult of Marbury come from? And so I think one way to do this is to start by linking the great chief, referred to by Bickel, Chief Justice John Marshall on the left, with the chief sometimes known as Super Chief. And of course the gentleman on the right is Earl Warren, a Californian of some prominence, actually from the Bay Area. Been state attorney general, I think, during World War II. Has somewhat complicated feelings about his role in the Japanese internment cases, which we'll say something about later in the course. Of course, Warren had just come to the court, in 1954-55, when the court reaches its great decision in Brown versus Board of Education, which we'll read about in some detail later. Now, I think the reason I put these two guys up here is in order to understand the claim I want to get us to think about in terms of being somewhat skeptical about Marbury. It's important to kind of have in mind a couple notions about its significance. So one is to try to distinguish conceptually, what we call here the power of judicial review from a conception of judicial supremacy. Habib, you might close that door, might help. Yeah. Judicial review, which is essentially, the doctrine we want to establish, says, you note here, it's about Gesundheit. It says it's about the power of federal courts to subject acts of other branches or levels of government to constitutional scrutiny and to enforce their judgments by legal decisions or by equitable remedies. The idea of judicial supremacy says through its power of appellate review, the Supreme Court acts as the final arbiter of the meaning of the Constitution, short of Article 5 amendment to the Constitution. So one says courts have a necessary role to play in terms of, important role to play in terms of ascertaining constitutional meaning. But the bolder version of judicial review is the idea of judicial supremacy, meaning that courts really are the final arbiter of what the Constitution ought to be. Now, that in fact has been a subject of kind of great scrutiny, of great controversy at different points in American history. Arguably, it should remain so today, and off and on during the course, we'll talk about other, as we go on, we'll talk about other occasions where this has happened. Now, the reason I introduce this distinction is, in part, it is important conceptually. It's important to think about what is the role the courts play, or we expect them to play, when and how was that established, versus what are the larger claims to be made on behalf of the authority of the court when it acts in that capacity. When one identifies a function, this is something the courts necessarily do. The other adds an additional claim to it. It says when courts do it, everyone else is preempted from doing it. So that's what the theory of supremacy means. Do you guys get the distinction? One says, of course, this is what courts have to do. That is essentially what the claim that Marshall, the first great Chief Justice, depending on how you think about John Jay, was that Marshall was validating somewhat defensively in Marbury. The more robust statement of this, attempts to kind of a breastbeating or chest beating exercise on the part of the judiciary, saying we're the guys who have to decide it. And if you want to think about a modern case that kind of wraps this up, or kind of embellishes it, you could pull out arguably Bush v. Gore, because there actually the Constitution seems to suppose that when disputes arise about disputes about the Electoral College arise, they're actually to be settled by Congress, not by the courts, and particularly when those disputes relate to a matter of state law. That's another wrinkle in this. But the court at that point was, in its own distinctive way, was asserting a doctrine of judicial supremacy that we have to arbitrate this, and for a variety of reasons, perhaps because what I call the cult of Marbury. Everybody acceded to that claim, though in some ways it's very problematic. The cult, I think, arises now. Something worth knowing here is that and we'll get back to this later in the class. This is actually the great litigator of Brown v. Board. I'm having a senior moment. Thurgood Marshall here. I hear Thurgood Marshall, the plaintiffs in Cooper versus Aaron. So here's the famous statement from Marbury v. Madison. It's emphatically the province and duty of the Judiciary Department to say what the law is. That's the kind of, it's the one capsule line that everyone likes to repeat. And the occasion when the court calls attention to this is a famous case called Cooper v. Aaron, 1958, which I'm old enough, I don't remember the case, but I remember the incident. So the incident comes out of, I don't know if anybody can guess. Oh, wait a second. Hold on, I've lost my slide here. Sorry, bad editing. What I had up here was a slide of the Little Rock school integration from 1958. At that point, Brown versus Board was in effect, but it was being massively resisted in the South. And the high point of resistance, well, not the sole point, but the high point of resistance came in 1958 when Governor Orville Faubus tried to, and citizens of Little Rock tried to prevent the integration of the Little Rock schools. Cooper versus Aaron is the case validating integration in Arkansas, and this is where the court, kind of incensed to assert its own authority, pulls out Marbury, pulls out the authority of Marbury to say we are the decision makers here, and the rest of you have to abide by that. So, and it's I think really more out of 1958 than out of the prior history that the cult of Marbury, the idea that Marbury versus Madison is the decisive and vindicatory statement of the theory, arises. So in one sense, what I say is the cult may be too pejorative a phrase, but the idea that Marbury is somehow decisive, that this was the precedent that establishes the path down which courts were bound to evolve, that seems to me to be a problematic statement. And the claim I want to try to make here as we go on is to say something about the importance of McCulloch. Okay, so that's the opening claim. Sorry, somehow lost the the Little Rock slides, but in any case, we'll have occasion to see them later in the class. Let me just kind of pick up on a couple points that we made the other day, just as the deep background here. So one, if we look to let's say the long decade, the decade and a half after the ratification of the Constitution in 1788, so it is actually a decade and a half to get us from ratification to Marbury, 15 years. So first point I want to stress, just to summarize what I did the other day, is to argue constitutional interpretation became very quickly an essential act of American governance. And the line between what was political and what was constitutional, so I tried to argue, is very hard to draw. It's permeable, and there are lots of incentives built into the political system for actors, in any branch of government, but particularly in the political branches, to escalate political arguments, claims about particular policies, what we ought to do, into constitutional arguments, claims about who has the right to decide. And the key thing for us to recognize is the development about ideas of interpretation was not strictly a judicial process. It's being done by all the branches, and indeed it's being done much more by the political branches, by the presidency and Congress in the 1790s than it was being done by the judiciary. Judiciary doesn't have that much to do. There are a few interesting cases, but as I noted, what you also see emerging very quickly, and this is why the case I mentioned of Hilton with a Y versus U.S. is so interesting, is political actors start to think strategically about the value of using the courts to advance their political objectives. In other words, in doing so with cases that probably were not genuine cases, that were contrived cases, meaning let's have some set of facts. And I think, as I understand it, I think the set of facts in Hilton versus U.S. it would have said it really should have been non-justiciable. There's some kind of factual fictions built into it that don't make any sense at all. But you can try to contrive a case to ensure a policy objective, which is what Hamilton, who winds up arguing the case in the Supreme Court, and you can read Hamilton's records on this, had in mind. So that's point number one. Second point, I just want to say, since I had a slide of my grandson up with Madison there, just to say something briefly about how we get from faction, as Madison talked about faction in Federalist 10, to the idea of political party, as that idea starts to emerge very consciously in the 1790s. So when you use the term faction, which is a very common term in 18th century politics, in England and America alike, all you essentially mean is something we might now call an interest group, or a faction could mean a group of kind of loyal members of a parliamentary or congressional little cluster of guys who kind of vote together, think alike. They have some common interests they're trying to advance. It doesn't really mean political party in the full sense of the term. So if you think about Federalist 10, when Madison says he's going to cure the mistress of faction, he's not talking about getting rid of political parties in the full sense in which we use the term. He just wants to say we want to try to develop some culture of deliberation, where the kind of parochial interest-based claims of faction will not prevail. We'll try to find some way for us to argue through better structures of deliberation about what our policies ought to be. He's not thinking about political parties. Faction has a somewhat narrower, or you could say somewhat broader meaning, but it doesn't mean political party in the full sense of the term. Now, the other striking thing that takes place in the 1790s, though, is that we do get a big development of political parties in this period, and it's done very self-consciously. There are groups of congressmen who are very loyal to Hamilton, and they retain the name of Federalists. They're very supportive of Hamilton's policies. John Marshall, the great chief on the left, was the leading Hamiltonian Federalist in Virginia. Marshall's based in Richmond. You can visit his house, which I've done a couple times, though not in recent years. Marshall was kind of, among many talents, was kind of a party lieutenant and very loyal to Hamilton in terms of his policies. And then, of course, there's the opposition party, which forms around Thomas Jefferson as Secretary of State, and Madison as his close friend and leading political ally in the House of Representatives. And which of them is more important? Some Federalists still think, or some interpreters still think that Madison somehow falls under Jefferson's dark star. Jefferson comes back from Paris with all these, woolly-eyed French ideas or whatever, and Madison was in some ways deferential to Jefferson. I tend to see them in this period pretty much as political allies. And then, of course, when Jefferson becomes vice president, Madison goes back to Montpelier with his new bride, Dolly. And so there was a kind of flipping of the roles, perhaps, that took place. But more basically, they're collaborating. And I think there are, two aspects of what they were doing that help us to, focus on why party arises. The Republican Party originates in the opposition to Hamilton's program, particularly that debate over the bank, but also Hamilton's larger funding scheme. The Republicans, meaning Madison and Jefferson, feel there's an awful lot of corruption that's surrounding, Hamilton's policies. You have a number of congressmen dealing in a somewhat speculative way with Hamilton's various instruments of public credit. There is a big kind of Bernard Madoff kind of scandal in 1792 around a guy named William Dewar. It's really kind of his own little version of a Ponzi scheme, which ended as most Ponzi schemes do, kind of spectacular collapse, indicating just as there had been the South Sea bubble in England back in the 1720s, which was a big the equivalent kind of Ponzi scheme or inflated stock speculation scandal. So Madison and Jefferson start organizing opposition to Hamilton's policies for a whole variety of reasons in the early 1790s. But I think the key turn, and that includes the debate over the necessary and proper clause and whether you have constitutional authority to establish a bank. But I think the critical turning point really came with the wars of the French Revolution, because originally I think the conflict was just taking place primarily within Congress over a particular matter of public policy. But I think once Americans have to start reacting to the foreign policy issues of the 1790s, to when Britain starts capturing American ships, defying our claims of neutrality, where there's a lot of sympathy in the United States for the French Revolution as a liberal cause that we ought to support. I think there you have the kind of issue that was, in fact, worked much better to kind of mobilize and start to attach public opinion. And of course, the growth of presidential power under Washington, I think particularly for Madison, to some extent for Jefferson, illustrated aspects of constitutional governance that they had not dealt with adequately before. I think Madison had a very weak sense of presidential power. Hamilton had a much better sense. Madison was essentially a Congress kind of guy, a legislative deliberator. Hamilton was a guy who better understood the capacity of executive power. I think they act upon those suppositions. So Madison has to play some catch-up in order to come to grips with what the presidency is capable of doing in this period. But I think also, once you have those foreign policy issues, remember I said about the Jay Treaty the other day, where John Jay says he could make his way across the whole country, from the light of his burning effigies at night. If you really had to do it, the way the path would be illustrated. So foreign policy has a kind of bite. And so what happens is what originally essentially factions within the government, factions of like-minded congressmen within the government, become, by the mid-1790s, active, a basis for actually trying to recruit voters to support party tickets. And now you find a lot of coordination taking place between what's going on at the national capital, within the cabinet and within Congress, in efforts to start mobilizing voters at the constituency level. And those are ratcheted up in turn by the presidential election of 1796. Right? So back, so long as Washington wants to be president, you can't have active presidential politics. Washington wanted to retire in 1792. Everybody says, no, you got to stay in office. So he stays in office. But 1796, he announces he's going to go back to Mount Vernon. He does it pretty late in the year, and the reason he did it fairly late in the season was to favor the Federalists, which means they're essentially favoring John Adams, who Hamilton, by the way, detested, as did Madison. A lot of people disliked Adams, not without reason. Great guy in lots of ways, but problematic in others. But even so, even though Washington delays announcing his intention to retire, once he does that, there is a party system that's already fully mobilized to campaign pretty actively. What that demonstrates, I think, is that the framers adopted a system of popular election back in 1787, it would have worked. But that's another story. The key thing is, you have this real incentive for party activity. So that's point number one. And I think a lot of it's driven by the presidency. If you want to control the government, you have to capture the presidency. And you can't capture the presidency if you don't have interstate, intersectional alliances. And to have intersectional alliances, you really suddenly look like political parties. You really need to start mobilizing. Americans develop a lot of ingenuity pretty quickly about how to mobilize for political purposes. The second thing that happens is that the people, in Madison's thinking, the people come to take on a new role. Back in the late 70s, Madison had been deeply skeptical, Gesundheit, about public opinion. He felt that most citizens, I don't know about us in this room, but he felt, but we're not, wholly representative here either. He felt that most citizens were just not qualified to form, to kind of establish informed judgments about public matters, particularly constitutional matters. He felt that public opinion really worked by having dignitaries within the community, articulate their positions and try to, sway and influence and really educate those around them. His position evolved pretty significantly in the 1790s for a whole variety of reasons. He gets much more interested in the whole question of what is public opinion, which was a hot subject of debate in the 18th century. I have a colleague at Villanova, Colleen Sheehan, with whom Colleen and I are going to co-edit something called the Cambridge Companion to the Federalist, Cambridge University Press Companion to the Federalist, which we're both kind of excited about. We can never get around to doing it. Always a problem in life. It's easy to say yes to interesting opportunities, hard to find the time to complete all of them. But putting that little quibble aside, Colleen actually has a wonderful book about Madison's evolving ideas about public opinion. And they did evolve significantly in the 1790s. So Madison, from having been very skeptical about the capacity of the people to act as guardians of the Constitution. If you remember the essay from Federalist 49 and 50, which we have read, which might appear on the prompt with a little bit of luck, where Madison criticizes Jefferson's idea for having occasional or periodical conventions of the people to deal with constitutional questions. Madison, I think, at that point was deeply skeptical about this. By the 1790s, he's moved back to what seems to be a much more, I'll use the term advisedly, a much more democratic position. The people have a role to play, he thinks, as guardians of, to use his phrase, constitutional landmarks. Constitution sets up a set of landmarks that we ought to follow in terms of reaching decisions. The people should be responsible for enforcing that. So this is the argument, by the way, that our former law school dean and my good friend, still a neighbor, and sometimes Chicago Cubs fan, although Larry Kramer thinks in his book, The People Themselves, Larry makes a strong argument about the way in which political parties really pivot on the idea that in the end, they should be actively debating constitutional questions. And when one side wins, the other side loses conclusively. A constitutional judgment has been made that institutions ought to follow. Think about this down the road when we get to the New Deal crisis of the 1930s, or maybe earlier. It's a kind of great way to think about this. So we have that aspect. Then third, the point that really helps to set up Marbury is this great question about the nature of judicial independence. So let's go back. Well, let me state this now, and then we'll develop it. So the whole theory of Article 3 of the Constitution ought to be, if we're dealing with this normative, some deeply normative way, why is it that we want judges to have independent tenure, or what we call life tenure? Or I should say, actually, why do we want judges to have tenure during good behavior, which we usually refer to as life tenure? Essentially the same thing anyhow. And the idea is that if they have, tenure on those terms, they will be completely independent. Once appointed, all the, they're, the only basis upon which they will act when they reach decisions is, they don't have to worry about their political careers. They don't have to worry about obligations to anybody else. So all they get to do is exercise their judgment, and judgment here really means a deeply informed, legally sophisticated basis of assessing, the different claims and counterclaims being made about constitutional issues, or any other kinds of issues for that matter. So that's the theory. The problem with this theory is that, I was about to put this as a kind of quasi-poli-sci question. Let's just say that tenure during good behavior is the independent variable, right? That's the prior condition. That's the prior fact, which is going to determine a couple potential outcomes. What are the potential outcomes? The ideal outcome might be exactly what we think it was designed to do, to promote judicial independence in the interest of impartial justice. Madison alludes to this at the very end of Federalist 39, for example. But you might have an opposite set of conditions, which arguably is the set of conditions we have now. So now we have a political process in which judicial nominations are deeply vetted politically, where we have lots of ways for ascertaining the partisan leanings of judicial candidates, where the idea of looking for moderation or just wanting to have independent judgment is, becomes secondary. The idea that, what we have is actually a capacity to lock our positions into the government over the long run. And what makes it work now, to some extent, is on the one hand, you have the Federal Society on the right and the American Constitution Society, whose new head actually is the daughter of our late colleague, George Frederickson, Carolyn Frederickson, George's daughter, who I think also went to my high school, where I'm going to be on Monday, which is why we won't have class here then. In any case, so we have these two societies, but also we have a whole other network of political, I should say NGOs or really public interest oriented associations, which put a lot of time into vetting potential political candidates. So we have this really interesting question: does tenure during good behavior, does that create judicial independence in the kind we idealize on the one hand, or does it really create a basis for locking your position into the government over the long run? If we voted on this, if this were last week and we were voting, I think the second answer is probably the better one, at least on empirical grounds. But the interesting thing is this is not a new discovery, right? This is actually what happened as we know, in 1801, 1802. And with a little bit of luck, so I have about 22 minutes left of me this morning, we can try to get to that. Okay, so that's the deep background. A lot of times I'm better on the deep background than the real story I want to tell. But I'll still try to do both this morning. Well, actually, there is a little bit more background to go on here. Okay, so now let's think about three claims about judicial authority, or three views of the function of judicial review, and then I will try to say something fairly briefly about the two cases. So what I really need is somebody up here with a whip to keep me moving in terms of my outline, but that would be, that probably wouldn't work very well. Do I have a different slide up here we want to look at? I'm just kind of strong or weak. Let's just get, so this is William Marbury on the left. And on the right, this is now, by the way, I've walked by this a number of times. This is in Georgetown. It's on M Street. If you're kind of downtown, Georgetown is next to, joins Washington, D.C. This is now actually the Ukrainian embassy. So God knows what's going on there. I mean, but it's, it's kind of when you walk down towards the end of the street, past Dean and DeLuca or whatever, and, you can, it's a nice area. Might be there in a couple of weeks. So I don't think I'll have time to go over there. So here's Marbury. He's actually a very prosperous guy. So, okay, since you guys have read Marbury and McCulloch in the class and discussed it yesterday, or for section, I'm going to try not to say too much about the details of the case because you know that pretty well, but I will try to keep working on the thinking about the background and the function and what makes these cases significant. Still try to make an argument about this. Okay, so the basic proposition what you were trying to discuss here, what I just gave, I hope, a lot of reasonable background for is which mattered more, Marbury versus Madison or McCulloch versus Maryland. I've suggested that I'm kind of skeptical, that I would take the contrarian position. Think that the McCulloch case, the bank case, in the end is a much more important case for a couple of reasons. Marbury is a very interesting case, but not important, or not as important as its modern cult suggests. That's the basic argument that I'm going to try to make here. But what does it makes Marbury a great case? Well, you might argue, as Alexander Bickel did, you might want to talk about its precedential value. You might want to say that this whole notion of judicial review was hazy and kind of fuzzy and not well defined, and might have somehow remained part of the constitutional vapors had this case not happened. I think that's wrong. I think the way in which, think about Hilton versus U.S. 7 or 8 years earlier, I mean, that indicates already that Americans, grasp the concept. If you go back and read Federal 78, Hamilton's classic statement of the theory of judicial review, if you simply read the supremacy clause of the Constitution, this Constitution, laws made in pursuance thereof, and treaties made under the authority of the United States shall be the supreme law of the land, and judges in every state shall abide thereby, or something. Anything in the Constitution or laws of their own states to the contrary notwithstanding. The supremacy clause is manifestly about judicial review. That's what it's endorsing. It's saying judges in every state now have the authority to enforce federal constitutional norms against the laws and constitutions of their own state. What you have to say explicitly about state judges, because they might have divided loyalties or they might be pulled in different directions, must implicitly be true. Imminently, I-M-M-A-N-E-N-T-L-Y, must imminently, or maybe imminently with two I's, must imminently and imminently be true about federal judges as well. A fortiori, who some of you guys will remember was a character in Catch-22. That's a literary reference you guys may or may not get. I once spent a couple hours in a bar with Joseph Heller, and that was a novel I read about 50 times when I was a kid, so still know quite well. Okay, so so there are some problems to the authority of Marbury, but one of its advantages, if you just think about conceptually, so one of the great advantages of Marbury, if you want to think about it as getting at some core set of theoretical propositions about the American Constitution, is it involves the judiciary judging an executive act or a lack of executive action, and then Marshall using it to invalidate a provision of the Judiciary Act of 1789 having to do with the question of whether or not courts can issue writs of mandamus in order to get something to be done. In other words, since you guys read about the case, and I don't know what people out in podcast land will make of this, or iTunes land, but I don't want to go back through the details of the case. But the key thing to understand is Marshall, speaking for the Supreme Court, is ruling on an executive action, Madison's refusal or refusal to deliver Marbury his commission, thereby to prevent Marbury from taking on the office to which Marbury actually had a personal property right. And for every right there must be a remedy. And then using that to say that part of the Judiciary Act of 1789, which had been the basis for setting up courts of justice, had given the Supreme Court a power it could not exercise. So you strike down a trivial part of a congressional statute. Next time this will happen will be in Dred Scott, 1857. Although other congressional statutes would be considered, so it's not as if the activity isn't there. But the next time something will be struck down will be with Dred Scott, which is also not a very popular case. In fact, it's by consensus the most reviled case in American history. But so in any case, if you think about it theoretically, Marbury's a great case because it implicates the three branches. So you get a chance to think about what's going on here. We okay over here? Good, thumbs up. Okay, so that's point number one. So that's the basic. I won't say more. That's the basic case for Marbury. Second point, it seems to me goes to the core proposition. So let's take a step back and ask, what is the real function of judicial review? What should its objectives be? So one set of arguments might be, well, if we use Marbury as the model, we have three branches of federal government. And so Marbury says that just as a matter of national governance within itself, not relating to the states in any direct way, just within itself as its own sphere, what we have here is a kind of ideal set of circumstances showing the role the courts ought to play as part of the whole system of checks and balances, right? So you need two houses of consent, you need the president of the Senate, but there may be occasions in which, in fact, and actually there are occasions where there are political incentives for courts to do, for the political branches to do something that everybody knows is constitutionally suspect but politically valuable. So in that sense, you do want to have the courts as a final resort. A good example here might be, kind of the recent flag burning cases. We have a big free speech doctrine which is expansive enough to protect flag burning, but in some parts of the country, flag burning is not thought of as being, the nicest activity, or something you want to publish, you want to punish for a variety of reasons. Anyhow, it's easy to see why congressmen would favor and presidents would assent to that kind of legislation because it's politically popular, depending on how public opinion is being ratcheted up, or what zany idea Rush Limbaugh has on any given day. You never know in advance, but you can always be fairly sure there'll be one or more, to kind of mobilize the base. But in the end, these guys are too smart to think we really want this doctrine to stick. So you can imagine cases, or you can imagine genuine ambiguity. and so on. You want the courts to resolve. I mean, what's interesting now, and we'll talk about this at the end of the class, is think about the amount of litigation directed against the Affordable Care Act, right? You know, including the King versus Burwell, the case that's now pending, as well as the Hobby Lobby case, and we won't get into the details of those now. Now to think about the role that interest groups can play in terms of advancing political agendas, you know, independent of the branches as an extension of deep ideological commitments in the body politic, that's another interesting question. But anyhow, so that's the case there. But I think, you know, the second function of judicial review, the one that I think historically has mattered more and which best describes, you know, not most comprehensively, but which best describes its real function is judicial review is essentially an aspect of federalism. Meaning, let's go back to a kind of Madisonian analysis from 1787, where, you know, Madison, who was obsessed with the state legislatures, you know, really, you know, deeply depressed by their activity and thinking for lots of reasons that was the level of governance where the wrong kinds of factious impulses were most likely to continue to prevail. So Madison's position would be what we really need is some mechanism for dealing with misgovernment at the state level. Now, one form of that could be the violation of rights of minorities within the states. But the other form, the other more obvious form, and the one that the convention was kind of close to agreeing on, but in the end does not adopt, is, so if states go wrong, they may do two things that are really bad. One is they might look for ways to interfere with and transgress against national measures, right? They might adopt interfering legislation, attempts to kind of prevent national policy from being implemented. States have independent legal authority. You know, they have the same statutory authority that Congress has. We don't know how strong the Supremacy Clause will really be in practice. So if states want to kind of mess things up, or if states have their own objectives that they want to pursue, they'll look for legislative ways to do it. If you remember, go back, remember the analysis we had about the Articles of Confederation, the point I stressed in, you know, Madison's, item 7 in Madison's Vices of the Political System of the United States, where he says, you know, if we really rely on state legislatures, that will never fail to render federal measures abortive. This is just an extension of that argument. So one argument might be they're always going to interfere, and that's bad. And the second argument might be, and essentially that's the McCulloch argument. That's to say they're trying to prevent the second bank, not the first bank, but the second bank in the United States from operating. The second argument might be maybe we have this more ambitious set of objectives. Maybe we want the judiciary to be able to intervene within the states, not just to prevent national policy from being implemented, but also to protect the rights of minorities within the states against factious legislation. That's a very prescient argument. In a couple of weeks from now, I'm going to make the case that Section 1 of the 14th Amendment, you know, coming after the Civil War, is actually the most Madisonian part of the Constitution, even though it's adopted 3 decades after his death, because it's the one that best fulfills, or at least lays the foundation for best fulfilling that part of it. Okay, but the key argument I want to make here is that, you know, the idea of courts serving this function, a federalism function, rather than a kind of intermediating function within the national government just taken by itself, that's really been the leading axis of judicial review. Most of the legislation the courts review, you know, or most of the cases, you know, the majority of cases where the court acts really have to do where the boundaries of federal and state law overlap, and you need to have some legal mediation for that. Madison's preferred solution, because he thought the judiciary branch was going to be very weak and very responsive, it might not really have the moxie or whatever, the confidence to oppose wrongly developed state laws. Madison wanted to give that authority to Congress on the assumption Congress would have political will of its own. A lot of ways, Madison's idea was wildly unrealistic and lots of problems with it. And I think he came to recognize them over the long run. But the solution that the convention adopted, that Hamilton also endorses, that Madison makes a fairly, it's not ambiguously worded, it's not, you know, it's kind of typical Madison statement. It could have been said somewhat more directly than it was. But if you go to the end of Federalist 39, Madison has a very clear statement about this is the role the courts are going to play. And they'll do it because they will have, you know, he endorses the theory of the independent judiciary because they'll do it under the best, you know, conditions possible in terms of their own independence. So that's the second big argument here. So really, I mean, so if we think of, you know, Marbury and McCulloch, the two cases we read about this week, as the leading points of this, It's the federalism argument more than the separation of powers argument. That's the axis along which I think we have to think about this. And then the third thing I want to say is that, Marshall's biggest critic was not Madison but Jefferson. They were distant cousins. I mean, that doesn't mean much because if you're part of the Virginia aristocracy, they're all cousins, one way or the other. That's why they just flop their names around. You could be, Harrison Bird Carter or Carter Bird Harrison or, Bird Harrison. I mean, they just got thrown a Randolph or whatever, and you have all these family names. They intermarry a lot, so they're probably all cousins of one kind. I don't think it was that big a deal. My kids have I don't know about you guys, my kids have 3 first cousins, which I had a whole bunch of cousins growing up in Chicago, a few of whom I still see, but, my kids have like 3. It seems to be kind of de minimis. Anyhow, putting that little quibble aside. So Jefferson and Marshall really detest each other for a variety of reasons. One of Jefferson's big criticisms of Marshall, one thing Jefferson was, Marshall worked hard precisely because Marshall was so aware about how weak the court was. Marshall works hard to kind of enhance the authority of the court. And one thing he wanted to do was, and it worked pretty well for most of his period. Marshall serves as Chief Justice for 3.5 decades. Went from 1835, 1836. Habib, remember when he dies?
35.
I think it's 35. Well, if Habib says 35, I'm tempted to go with that. So, but essentially 3.5 decades. 1801 to the mid 1830s. For most of this period, it starts to break down towards the end. Marshall tries to get the court to speak with one voice, often his, as opposed to issuing what are called seriatim opinions, meaning S-E-R-I-A-T-I-M, Latin word, meaning each judge should, or the judges individually should try to offer their own reasoning. If they do that, then the body politic, Jefferson being the greater Democrat, then the body politic will have more of a basis for thinking about what the court's doing. Right? If they see what the legal arguments are, if public opinion is informed, then they or we can try to sort out what's in dispute. If the court speaks with one voice, though, if you're thinking strategically, as Marshall was, about what's its place in American jurisprudence, that'll be a big incentive. Okay. So I've got about 7 or 8 minutes left to try to wrap this up. So let me try to do something pretty quickly here. And since you guys have all read Mike McConnell's discussion of this, I don't want to belabor the point. Yeah, the obvious point I want to make is, that when I started to say some minutes ago, is what we worry about now in terms of how the judicial appointments process is operating, because so many interest groups are so highly mobilized to vet and channel and favor and oppose different judicial nominations. The appointment system is essentially a disaster. A lot of commentators think, because it is so highly politicized. So certainly, as a matter of degree, we're in a difficult situation. But the basic concept is not a modern invention. What happens in 1800, 1801 is when the Federalists realize they're losing control of the 2 political branches of government, and they lose control in a decisive way. The election of 1800, what Jefferson called an end to the reign of witches, was it means an end to the kind of period of the Alien Sedition Acts and the violation of civil liberties. This is not a gendered comment, by the way. It's just make that point in passing, that the Republicans win decisive majorities. It's often said, by the way, and I think this argument's really wrong, is that the way Jefferson wins is essentially still because of the 3/5 clause. We'll come back and talk about this a bit next week. It's essentially because of the 3/5 clause, because the South gets more electoral votes. If you look at the congressional results, and you assume the congressional results are a much better index of how the nation's voting, because the Electoral College was being, five states changed their electoral rules for the election of 1800 on deeply strategic calculations. If you look at the congressional results, there's no doubt about the depth, the extent of the Republican victory. So they take over both houses of Congress. They have to start out the issue that Jefferson and Burr are tied because, for the way in which in the Electoral College, don't look so puzzled, Amy, it's true, because, electors did not vote separately for president and vice president. You guys know the story of 1800? So electors cast 2 votes, but they're not voting separately for the 2 offices. What they're voting for, the guy with if you have a majority, the guy with the highest number of votes becomes president. And if you have a majority, the guy with the second highest number of votes becomes vice president. It's, Pretty simple. That's why Adams and Jefferson, the rivals in 1796, became president and vice president. And actually, what happened in 1796 is Adams beat Jefferson by 3 votes, meaning a swing of 2 would have carried the election. And in a couple states, there were district elections. Electors were chosen by districts and not statewide. And so Republicans started recalculating. So the Republicans lose 1 or 2 electors. I think they lose an elector in Virginia, in Richmond. The same thing takes place in North Carolina. So states start flipping the rules. And so Virginia goes to a statewide winner-take-all rule. And when the people in Massachusetts, obviously John Adams supporters, see what they're doing, they go one better. They say, we're just going to have the legislature, which is solidly Federalist, appoint the electors. So that's the disparity you get between, that's why the vote for Congress is in some ways a much better index of political opinion in 1800. So in any case, once the Federalists realize they're losing control of government, they pass the Judicial Act of 1800, creates a whole new bunch of judgeships as well as magistracies or JP positions like the kind that Marbury on the left was going to occupy. They're trying to entrench their, in the one branch of the government they can still control while they're still in power. Before new Congress is not going to meet until the fall of 1801, so they try to lock their position in. So the political, again, go back to my big argument. One has to think about a constitution setting up, in effect, a game theoretic matrix within which the positions we favor are not positions we favor out of abstract principle. We favor them out of partisan calculation. And once you start to think strategically about this, so Taylor is a poli-sci major, you see where this is going immediately. Once you realize that possibility, then you just you naturally follow the incentives. So that's what Republicans do in 1801. They set a Judiciary Act. Marshall serves simultaneously as Secretary of State and Chief Justice, because that's actually that's not barred. At least for a while. He's not going to stay as Secretary of State for too long. And then, of course, in 1802, Republicans repeal it. And in 1803, 2 cases are pending. Marbury is the weak case. Who cares? He's a nice guy, actually very prosperous, very nice house in Georgetown. God knows how much it would be worth today. Hope the Ukrainians can still pay for it. So there's a case that's trivial in terms of its consequence, and then there's the big case of Stewart versus Laird, which goes to the issue: can the Republicans actually abolish all those judgeships? I mean, once you're appointed to as a judge, you're supposed to serve tenure during good behavior, right? How could you give Congress the power to abolish judgeship? This is not a This is a pretty good objection. Actually, one of the things that happens at the state level in 19th century politics, state judges don't have the same protection, neither then nor now. State judges don't have the same protection that federal judges have against this kind of manipulation. A lot of times, if state legislatures don't like the judiciaries of doing, they just abolish the judiciary and remake them with a new, with another piece of legislation. In a sense, that's what's pending in 1802. We're kind of Federalists are undoing. The Federalists are stripping tenure during good behavior from a number of judges. Not by going after them individually, but by abolishing the positions they occupy. Politically, that's. I don't think. I think if that issue came up today, Stewart versus Laird notwithstanding, it would be tough to pursue it. So in any case, so we wind up with this very strong statement about Marbury. In Marbury, it's a statement that looks very good to us. It's great to analyze conceptually for the reasons I suggested. But the one I think that really mattered was the statement we get from McCulloch versus Maryland. And since we have to wrap this up, I won't say more about that substance. I'll come back and say something about this. Actually, I'm not here on Monday, so next time we're going to meet is Wednesday. And we'll just, have to play some, as usual, have to play some catch up then. The one thing I want to say is if we look forward another decade and a half past Marbury and get to McCulloch versus Maryland. McCulloch versus Maryland is a great statement in lots of ways for that broad reading of congressional power that Hamilton and other Federalists had favored all along. I mean, in the end, it is all about the extent of the necessary and proper clause. In a lot of ways, it's just a restatement of the arguments from 1791. But a couple of interesting things happened about this. One is that a guy I'll discuss on next week, a guy named Spencer Roane from Virginia, who's the marshal's equivalent in the High Court of Appeals in Virginia, tries to mount a systematic attack on the federal judiciary. And he tries to recruit Jefferson and Madison to support his positions, and the difference between them. You guys are going to read about this. It was assigned for this week. You don't have the documents, but I think it will be part of the prompt that I'll use for a midterm exercise. This idea is taking place in my mind. Just hold on one second. So we have this really interesting debate about the extent of judicial. Ooh, I always forget about that door. We have this really interesting debate about the extent of judicial power in 1819, which pivots on McCulloch versus Maryland. But McCulloch versus Maryland also coincides with another major crisis in American history, which we know is, this is a great week for the M words. There's the Missouri Compromise, which introduces these great issues of sectional tension. So 1819 turns out to be a kind of a, I won't say a pivotal year, but kind of a seminal year in terms of trying to articulate the kinds of constitutional issues with which Americans are going to be struggling over the next 4 decades. And that's where we're going to pick up next Wednesday. Thanks a lot.
This program is brought to you by the Stanford Humanities Center. For more information, please visit us at shc.stanford.edu.
For more, please visit us at stanford.edu.